Welcome, and thank you for tuning in. You're listening to the Beyond 50 radio program. I'm Daniel Davis. On the program today, we're going to be talking about something known as misinformation about self-defense rights. We're going to also discover what the laws are and what has sparked major debate over the misapplication of lethal force in civilian communities. We're also going to learn about major issues in self-defense cases and the legal approaches used to resolve them. The result is less confusion and greater understanding of what self-defense is and how to go about determining if a homicide is self-defense or murder. On the program today, we're joined with General Bruce Lawler, who was one of 5 senior White House staff members who wrote the plan to create the U.S. Department of Homeland Security. I'd like to welcome to the Beyond 50 radio program today our guest, General Bruce Lawler, talking about his book, When Deadly Force is Involved. Bruce, welcome to the program.
Well, thank you for having me, Daniel. It's good to be here.
Now, let's talk about what your book is about so people get a clearer understanding and what's going on out there.
Well, the book is about how the law has traditionally handled self-defense shootings. The idea is it's focused on when it's permissible to use deadly force to protect oneself from danger. And I wrote it to give people a way to think through the idea of having a firearm for personal self-defense.
I know it seems that every time we go through a new election cycle, one of the things we hear a lot about is that of the U.S. Constitution's Second Amendment, the right to conceal and bear arms. And I think this day and age, most people don't have a clear understanding of what that actually is. We've even had a scholar who was a constitutional professor who was talking about this very thing. And he says, take a look at when that was actually first created. Was at a time when there was the possibility that militias were needed and that you needed to arm yourself. But this day and age, he says, maybe not so much. So why do people feel confused about what their rights are when it comes to the Second Amendment?
There's a lot of debate about the Second Amendment, a lot of concern on both sides as to whether or not the firearms ownership is regulated or not regulated appropriately. I think in terms of self-defense, it has been identified. It is part of the debate, I guess, because it's been identified by the United States Supreme Court as one of the reasons that justify individual right to own or right to bear arms. But in a collateral sense, self-defense is really not necessarily about firearms. It's about the ability of an individual who is without fault, an innocent person, to use deadly force to protect themselves against an imminent unlawful threat of death or serious bodily injury, provided there's no reasonable alternative. And that legal doctrine doesn't just apply to firearms. It applies to any tool that a person might use to defend themselves, a baseball bat, for example. So the principles are pretty much the same. I focused on firearms because there's just a very large number of firearms in the country today, and there's a lot of interest in having them for personal protection. I think it's fully 60-something% of people who respond, gun owners, say that they possess a firearm because they wish to be able to protect themselves.
Now, looking at post 9/11, we certainly feel that there are terrorist threats all around us, and and we're kind of wondering, what federal, state, and local governments can do that can protect us from these particular things happening. And it seems that there are many more targets than the government can protect. So let's talk about the idea of deadly force, and in the case of your book here, what some of the truths are about the legal side about standing your ground, and what would surprise our listeners.
Sure. You are right about the terrorist threat. I mean, I don't want to overstate the terrorist threat, but there certainly is a perception in the country that we are more at risk, and I think it's probably because the nature of the threat has changed. When I grew up, my parents told me, and I told my daughters, if you ever get in trouble, go to a place where there's lots of people, go to a place where there's lights, where there's activity, and there's safety in numbers kind of thing. That's not so much true anymore because we're seeing that places where people congregate are in fact targets, whether they're churches or schools or shopping malls or nightclubs. So there's a perception of greater risk, and I think that's caused some concern, and it's driven some people to think about what they can do, and that relates to the larger question, and why I wrote this book. I've spent quite a bit of time, a lot of years, thinking about Homeland Security and working in it. And, we have spent billions of dollars trying to figure out what state and federal and local governments and what the private sector can do to protect the systems that many Americans rely on, transportation systems, healthcare systems, water systems. But we haven't put much intellectual effort or energy or resources into thinking about what is the role of the individual in this modern-day environment for his or her own safety, and what can they do? What can they be expected to do? And so that was the purpose of the book, was to address that issue, is what is it that the individual can do? And ultimately, you reach a point when you're thinking about various options that the individual is on his or her own. And at that point, they have to fight or perish. And so the question is, well, when can they fight, and what does the law say about that? And so that's what the overall purpose of the book is.
Now, let's talk about self-defense cases. What are usually the major issues that are involved when it comes to a case when it gets to court?
Well, I think it's fair to say that anybody that's involved in a self-defense shooting is going to go through a pretty rigorous process, but it's well known, and so there's a lot of confusion out there about, well, self-defense is so complex and nobody understands it, and only lawyers understand it, and I don't agree with that. I think that's wrong. I think there have been thousands of self-defense shootings. The law books are full of them, and the issues involved in them are pretty much common, the same in almost every one. So let me give you a couple examples of major issues. The investigation will look at, for example, was there a deadly threat, and what's the nature of the deadly threat? And what they're looking for is some act, some behavior on the part of an aggressor that other people would look at and say, yeah, that is a pretty clear indication that somebody's about to get hurt or seriously injured. So deadly threat is an issue. It's always an issue. Was there a deadly threat or was there not a threat? How soon is imminent? In other words, the threat has to be right now, has to be immediate. It's about to happen. It's not some time next week or next year. It's right now. And if there's time for options, for alternatives, that's a factor that weighs in there. It's in every case. There's a question about the behavior of the shooter. Is the shooter in some way responsible for bringing about the confrontation, for getting in the argument? You can't start a fist fight and have the thing get out of control and then claim that you had to act in self-defense to save your own life. The law doesn't recognize that. It won't permit you to do it.
Right.
So those are some of the things that you run into in every self-defense case.
And you touched on something that I think is real valuable for our listeners to come to understand. It seems that, and this is just my thinking, but if you're going to arm yourself to a degree, it's like you feel that perhaps you're trying to prepare for trouble. But in a way, you could almost think that, well, don't you think you're kind of somebody who's out there looking for it?
I'm not sure I understand your question on that.
Well, generally speaking, when a person arms themselves, they tend to be in a position of power. So, in other words, they will tend to possibly escalate a situation they may not normally escalate because of that feeling of protection of power that they may have over another individual who isn't armed.
I suppose that could occur. My experience is that it's just the opposite. There's sort of a saying that you encounter a lot is an armed community, is a polite community. That people tend to, I think, de-escalate because the consequences are so serious. Nobody wants to draw a firearm and kill somebody. Anybody that goes into this thought process about whether they should own a firearm and thinks that way, frankly, shouldn't own a firearm. Self-defense is strictly a passive concept in which a person only acts as a last resort when there's no alternative but to either submit to death or serious injury or to fight. And then the question becomes, when can you fight and under what circumstances? So I don't view it as empowering people over other people, and I haven't experienced that in the folks that I know. So I think it's more an area where people need to understand and want to understand how they can use it safely so they can avoid situations where they might otherwise do something they shouldn't.
Now, you certainly have extensive military and civilian experience when it comes to the security sector. And I'm curious, so share some, I guess, a story or two that could actually give our listeners an idea that are based on actual shootings to describe situations in which self-defense was claimed.
Well, for example, and I'll use this to illustrate, I guess, why the claim of self-defense wasn't recognized. You have a situation, for example, you have, since I'm an Irishman, let's call them Pat and Mike. They get in a fist fight at work. It's very, people have to separate them. They're both sent home. Later on that night, Pat hears a pounding on his door in his apartment. He goes to the door, looks through the eye hole, and sees Mike there, and Mike's screaming at him and swearing at him. So Mike goes and gets a firearm and opens the door, and the confrontation escalates, and pretty soon someone is killed, and the other party claims, let's call him Pat, claims self-defense. In that situation, I mean, that is not an unusual situation. People think that their first reaction is to arm themselves, to protect themselves. But at the same time, what really happened there is that Pat was in a relative position of safety. He was behind a locked door. And Mike may have been screaming and hollering and pounding on the door, but at that point in time represented no immediate threat to him. He couldn't reach him. He couldn't hurt him. He couldn't do anything to physically injure him. As soon as Pat opened the door, well, that whole possibility changed. So Pat, in effect, enabled and contributed to the subsequent confrontation by exposing himself to danger that he certainly didn't have to expose himself to. Instead of staying inside the locked apartment and simply calling the police, which would have been reasonable behavior under those circumstances, he chose to arm himself and open the door and confront a person who he obviously knew was angry at him and hostile. In that kind of situation, the Pat, the person who opened the door, is likely going to be held liable for or responsible for Mike's subsequent death. Now, whether that's a homicide, murder conviction, or manslaughter conviction, I don't know. But the reality is that he exposed himself. He contributed to the progression of events that ultimately led to the shooting. So that's an example of how it works.
Now, let's talk about, it sounds like you touched on something that people can become aware of, the Castle Doctrine.
Yeah, the Castle Doctrine, they exist in almost every state. In fact, that virtually every state has a Castle Doctrine or some variation of it. And basically what the Castle Doctrine says is that when a person is inside their home, in their dwelling, they do not have to retreat before using deadly force against an invader, against someone trying to break into their home or someone entering their home unlawfully. They don't have to try to run and hide or get away or think of other things to do when they're inside their home. Now, one of the variances of the Castle Doctrine, which causes some confusion, is that different states define home differently. So in some states, the home may consist of just the apartment, the inside walls of the dwelling place. In other words, your actual living space. Other states may include porches on the outside of the house. Other states may include an attached garage. Somebody else may include a detached garage. So the area of coverage of the Castle Doctrine varies from state to state. And it can be a little tricky because if you're used to living in one state that says you can stand your ground, so to speak, on any place on your property, and you suddenly move to a state that changes that concept entirely, and you can only stand your ground inside the four walls of your apartment, it can cause confusions. But the Castle Doctrine in general is a response to the duty to retreat, which says that before you use deadly force against another person, you have to try to seek a path of escape, a reasonable way to avoid the use of deadly force. Basically, the Castle Doctrine says that doesn't apply when you're in your own home.
Now, you touched on something that I think is clear that we should have a lot more clarity about, and that is reasonable fear. You know, the idea that are you in a situation that can be considered deadly or very serious, that you might take an action such as using deadly force to protect yourself. But that seems to be a perception that can be different for different people, wouldn't it?
And it is. And it frankly depends on the circumstances of the factual circumstances. Let me say, first of all, that fear alone is not enough. You can't shoot anybody because somebody else because they appear scary or you're in a scary part of town. That doesn't work. There has to be some overt act, some hostile behavior directed at you, focused on you, that other people looking at would say, yes, there is a threat there of death or serious bodily injury. It's a difference between what's known as an undifferentiated fear and a focused fear. If you're in a parking lot at night, a woman is working and leaves late at night and she's in a parking lot and somebody appears to be following her. Well, she's frightened. The red flags go up. She needs to be careful. She's scared. She doesn't have any grounds at that point in time to shoot anybody because her fear is undifferentiated. There's nothing in that circumstance I've just described that suggested there was a threat that was focused on her, that the stranger who was in the garage with her was somehow focused on her. And now you take that fact situation, you change it just a bit, and suddenly you've got the guy reaching into his pocket, walking directly, focused on her as she's trying to get into her car. That's a different situation. Now you've got a threat to her that is focused on her, directed at her. And at that point, it is very reasonable for her to fear that she's about to be seriously injured. So that's sort of how reasonable fear works. It changes on the circumstances. For example, suppose our woman in the parking lot weighs 105 pounds, 110 pounds, and suddenly she's being confronted by some guy that weighs 260 pounds and is all muscle. I mean, the disparity of the ability to defend oneself is so obvious there that the woman is at significant disadvantage. And that also would factor into reasonable fear. You get a person who's handicapped somehow, in a wheelchair, suddenly confronted by somebody with full use of their limbs and the ability to maneuver around them and place them at a disadvantage. That factors in. So the question of fear really depends on the circumstances that a person finds themselves in. And in every case, the best judge or the ultimate judge will be other people who look at the totality of the circumstances and say, yeah, it was reasonable for somebody to be afraid under those circumstances.
Now, what happens in a case, let's say that somebody uses deadly force but they missed their mark, the threat that they were actually aiming this force towards. And you see this. This actually does happen, but then somebody innocent gets injured or even killed. What happens?
Yeah, that does happen. And what it is, it's known as transferred intent, and that's the way it is decided. And let me try to explain that. The key element in every self-defense shooting is intent. What did the shooter? What motivated him or her to pull a trigger? And if the motivation is hostility or ill will or some sort of antagonism toward the victim, then that's murder. But if the intent, the purpose of pulling the trigger, is to avoid harm, to save oneself from danger, to escape, that's a completely different intent. So if you start with that idea, what was the intent? So if the intent was to avoid harm, then the intent supports self-defense. And that intent will transfer to whatever the results of the act are. So if you intend to shoot your assailant, someone's attacking you with a knife, and you pull the trigger, miss them, and hit an innocent person, the intent travels with the bullet. And so the intent was not to kill an innocent person. The intent was to protect oneself. That still supports self-defense. The question then becomes a second question, which is, was it reasonable under the circumstances for the person to make the mistake that they made? So if you are, we go back to the garage, and the woman is trying to get in her car, and the man is coming at her, pulls out a screwdriver, and looks like he's going to stab her, and she shoots him. Well, then if that's a mistake, that turns out the person's trying to help her with open the door of her car, the question becomes for people to judge, under the circumstances, in the garage, late at night, and so forth, was it reasonable for that woman to make a mistake like that and be frightened as a result of it?
Well, it seems to me that you might want to manage the times and areas you might find yourself feeling any type of threat in. I used to, many, many years ago, before I broke into broadcasting, used to tend bar. Oh, my goodness. Yeah. Some of the nonsense you see coming up in there, you realize people didn't end up killing each other sooner than they did.
Yeah.
And especially you throw, alcohol in the mix, and boy, you can come up with all kinds of perceived threats like, no, my quarter was next on the pool table. No, mine was. Okay, you're going to fight over something stupid like that, but you'd be amazed what people are willing to fight over in situations like that. But the point being is, it's a matter of, let's say, like this woman who feels that sense of insecurity going to the garage to get into her car late at night. What could you do to change that perceived threat so you don't feel threatened, that you might make a choice that could actually go very wrong for you, even though it seems reasonable at the time?
Yeah, that's a very difficult question, because the self-defense really is the choice of last resort, and so I know people take precautions. I think generally that women are more conscious of their environments and their security than men are. We tend to bumble around and stumble around into things, where most women are pretty observant about what's going on around them. And so, that's where the situation where you begin to talk about awareness of one's environment and trying to set boundaries so that you're looking at the behavior of an individual, and based on that behavior, you sort of increase your threat posture. You become more concerned as the behavior becomes suspicious in your mind. That's about all I think you can do, other than maybe change to the day shift, but that's not always practical. But to go back to your bar situation, I think that's really an interesting area, because fist fights, and there's a lot of them, as you know, normally result in a bloody nose and somebody swearing at somebody else, and that's sort of the end of it. And a fist fight in and of itself.
We at least hope so, but I actually know of a couple of stories where it didn't end up that way. What happened was there was a confrontation, a fist fight. Then the next thing you know, it's done. One of the people are on their way home, doesn't realize he's being followed by the person that he fought, and then he's shot and killed right there before he gets to his house. And I say to people out there, if you can avoid fights this day and age, you're better off actually retreating, just walking away from it, than trying to stand your ground, because you just don't know what that other person's going to do if they're able to get up and walk away.
That is absolutely right. That is absolutely right.
And these are facts. I'm not just making this story up. These were things I've actually seen happen over the years, and it's just like, nope, hey, I don't know what I did or said to upset you, but here's a beer.
Well, that's right. If you can de-escalate, that's the thing to do.
Agreed.
And I think the one thing you can sort of take away from this is that the overarching question in every single self-defense case is, was it really necessary? Was it really necessary to use deadly force in order to take another life, in order to save your own? And there's not, let's say the benefit of the doubt is going to go to the victim. It's going to go against you if there's any question about whether you acted properly. The likelihood is that the arbiter, the person that makes the decision, is going to suggest that you didn't. And that puts you in a lot of trouble. So deciding that you're going to possess a firearm for self-defense is a very serious undertaking, and that's why people need to sort of look at the issues that are raised in self-defense cases, like what is a deadly threat, how soon is imminent, and then decide for themselves whether they want to take on that responsibility.
I'll tell you, it really is a complex web that we have when it comes to the idea of self-defense. I think sometimes people take a look at a Western, and you got a couple of people fighting over who cheated who in a poker match, and as soon as the gun is raised, you have a gunfight, and it was all legal sort of a thing, but we don't live in those times anymore.
Thank God.
The book is When Deadly Force is Involved. Our guest joining us today, Bruce Lawler. Now, is there a website people can find out more about your work and how to get the book, things like that?
Sure. It's brucelawler.com, and you can order the book there from multiple different sites, and there's some other documents on there, articles that I've written about why I wrote the book, and a number of thoughts about a little history, I think, of self-defense and those kinds of things.
And I certainly believe, as it sounds like you do as well, that probably the best training we can give ourselves is knowing how to not put ourselves in a threatening situation in the first place, and if so, then knowing how to manage it to a level that we don't have to think about moving in a direction of using deadly force. Bruce, I want to thank you for joining us here on the program today. It's been a pleasure to be able to share this with our listeners.
Well, thank you for having me, and you have a great day.
Will do. We want to thank you, the listeners out there, for tuning in. You can also discover more by visiting us at Beyond50Radio.com. That is the number 50. You can also sign up for our weekly e-newsletter and stay up to date with what's going on in the world of Beyond 50 as well as upcoming shows. I'm Daniel Davis. Thank you for joining us. This is the Beyond 50 Radio program, and remember, live your day past halfway.